This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Joviet. Tonight we're talking about medical mistakes and nursing home negligence. We expect our doctors and nurses to take care of us. Sometimes it goes wrong though. If you don't heal, is that the doctor's mistake or sometimes things just don't work out? When is it bad luck and when is it something that you need to go see a lawyer about? Okay, what if it's a pharmacy? If a pharmacy misfills the prescription and you take some kind of medication that you weren't supposed to take, is that a malpractice case? We're also going to talk about standards with nursing homes. How do you know what to be looking out for your loved ones? What kind of proof would you need to go after them to try and make some recovery? Call in your questions, the 31 Law Call number, 256-536-0077. You can call in and be live on the air, or you can text us to that same number, and we've got some of your text messages coming in. You can also email any legal question any day of the week. You send it to lawcall@waytv.com, and when we get to a show that's on point, we pull out some of your questions. We've got some of your email questions tonight. Michael Timberlake's here from Timberlake, League & Brooks. Good to have you here.
It's great to be here.
You guys handle medical malpractice, nursing home negligence kind of cases, pharmacy mistakes. So let's talk about some of the things that have changed. Medical mistakes. This is a surprising piece of data. For the year 2024, there has been an increase in medical mistakes of 13% over the previous year. That's a huge amount.
Yeah,
13%.
I mean, so basically what they look at, the Joint Commission comes in and does a survey, and they look at the numbers, and they've said that sentinel events, which are instances that result in serious injury or death, are up 13% over last year. That's a huge increase. Now, in terms of, drilling down through the specific numbers, they've looked at, okay, well, where these come from? Well, they've looked at, surgery errors are up, wrong site, surgery errors are up, and again, 13%.
Wow.
So the type of errors you see are wrong site, wrong patient, wrong procedure, wrong implant. But those are serious type of things that you see, and a 13% increase is huge.
In 1 year, that is remarkable.
Absolutely.
Okay, let's talk about nursing home cases. So it's important to investigate whether the home was complying with the legal requirements for care.
Sure.
So talk about some of the reasons that you see for why injuries occur in nursing homes.
Yeah, I mean, so nursing homes, there's there are regulations, federal regulations that they're supposed to be inspected. They don't get the inspections they need, but you can make a complaint after an incident. And they will typically respond to those fairly, fairly quickly. What you see in nursing homes typically are, just basically lack of attention type things. We see falls due to inadequate staff. You have somebody that needs 2 people to help them. They only have 1 person that's helping them, if any people that are helping. They don't have people that are trained to do the job. You have LPNs that are doing RN jobs. You have people that are new on the job trying to take care of very complicated patients. And sometimes you just don't have the equipment or the facilities that they need in terms of beds, alarms, types of things like that to make sure that the patients can be safe.
Do rehab facilities fall into the same kind of category?
Yes, I mean, you typically talk about, you have a rehabilitation facility. This is a short-term rehab facility. Some of the nursing homes, or that we call them, are skilled nursing facilities that provide long-term care, also provide short-term care, then long-term care. So they all kind of fall under the same type of thing. You do have acute rehab hospitals that are more short-term stay in terms of weeks instead of months or things like that. But the regulations are going to be similar for those.
So a viewer is texting about a rehab situation. Says, I was in rehab after having blood clots. They over-medicated me and they didn't do anything about it. Do I have any rights concerning that?
Yeah, I mean, absolutely. Whenever you have a situation that happens in a healthcare situation, you want to make sure that you run it to ground. The least thing you do is just talk to the administration and say, look, I don't think this should have happened this way. What can you do to fix it? What can we do to make sure this doesn't happen to somebody else? And a lot of times you look at it and we'll get calls and we'll say, well, first thing we need is the medical record. So we need the record from the facility to determine what happened, at least what the hospital or the facility says happened, so we can compare that to what you have to say to see, what facts we think we can prove. those situations, once we review the record, we'll give you an honest opinion about, do we think that this is something where we could prove there was a, substandard care, and whether that could result in a distinct injury. In a situation like this, a lot of times we look at what's the cause and the effect.
Okay.
Can we, a lot of times we can say, yeah, this is probably something that, shouldn't have happened.
Yeah.
They
gave you too much medicine and we could prove that.
Somebody ran a red light,
okay.
And then you look at it and you say, okay, well, what was the injury that was a result of that?
Gotcha.
And in medical cases, you kind of look at that two ways. One is, is there a distinct, definite injury that you can prove that's a result of the malpractice? Because that's always going to be a defense. They'll come after you on the medicine, for sure, in these cases. And then the second part of it is there an injury that is significant enough to justify the time, effort, and expense of pursuing a claim for medical malpractice in court? And unfortunately, these cases can be expensive, time-consuming, and a lot of them are not won. So those are, things we take into consideration.
So if they gave you too much medicine, but you were okay, you were fine.
Sure.
That's not a case.
I've had that case, settled that case. Didn't settle it for a lot of money.
Okay.
But at the end of the day, when you look at it, you've got to kind of, size it up and decide whether this is something that you want to take on. When we take on a case, I want to take it on till the end. I don't want to come in and just capitulate.
Okay, because we had somebody else that had texted in saying that they had a case, different kind of case, and their lawyer withdrew after being on the case for 4 months, and they're saying, can I get another lawyer at this point?
Right.
So you can change lawyers, and lawyers don't have to continue on a case, right? If they, for different reasons.
Sure. I mean, and those are, in medical cases are kind of the most typical in this situation, where a lawyer will either look at the case, evaluate the case, and take some time. Sometimes you need experts. Sometimes you need nurses, doctors, to tell you whether or not you think you can prove your case. And then after you evaluate it, then you kind of have to do a business evaluation about, okay, it's going to cost this much money to put into this case. Is it going to potentially be a return for the client, the person that was injured? And is the lawyer going to get paid? So there's a lot of things you have to look at.
We got this email question from Marty. Marty says, I want to sue a nursing home over my father's poor treatment, but my sister doesn't want to. Do we both need to be in agreement for a lawsuit to go forward?
Well, actually, no, not in Alabama. So if it is a claim for injury, then someone who is, they can't sue for themselves because they don't have the ability, they're incompetent, and they don't have to be adjudicated incompetent by the court of law. You just have to say that they're not able of handling their own affairs. They can sue through what is called a next friend. The next friend is a person that doesn't necessarily benefit from the lawsuit, but they can be a representative of someone who can't handle their own affairs. And if it's an injury case, then you can sue through next friend. It wouldn't matter if your sister wanted to be involved or not be involved. You could still do that. All the proceeds would go to your father. You wouldn't get anything from the suit, but you have the ability to serve in a representative capacity.
Okay. If the father were still mentally competent and he didn't want to pursue the case, can you go after somebody?
No, you've got to, if somebody's mentally competent and they're in a position to say no, then they can say no.
Okay.
If it is a death, if it's a situation where somebody dies, the person that has the right to file a lawsuit for wrongful death is the personal representative of the estate, and that goes through probate court. That can be someone that has been designated in a will. If there's no will, then the surviving spouse, if there is one, has a priority for about 45 days, and then it goes to then anybody can file. So you could, could be a sibling, it could be a child, it could be somebody else, it could be a total stranger. They can file to be appointed personal representative of the estate and then pursue a claim for wrongful death.
Okay, that was after a death. We've got a series of questions coming in like that. A viewer is writing in, do I have any recourse to file a complaint as the sibling of a patient who fell in rehab, or can only the husband file a complaint? Basically, I was told I have no right to complain.
Well, the truth is, legally, you have a right to complain. You could file as long as the person who is injured wants to make a claim. and they will say, look, I want you to make this claim for me, or they are mentally incompetent and unable to do it for themselves, then you can make a claim.
Okay, we're going to take a break. We've got callers on the line. Bobby, don't go anywhere. We'll be right back with you. And the rest of you can call in as well. We're talking about medical negligence, nursing home cases. Call in the 31 Law Call number 536-0077.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back. Tonight we're talking about medical mistakes, nursing home negligence. So if you or a loved one have been injured by a medical mistake, nursing home problems, or even a pharmacy that's prescribed the wrong thing and you've been harmed by that, calling your questions. We've got Bobby on the line with a question from Huntsville. Michael Timberlake's here from Timberlake, League & Brooks. Bobby, thanks for waiting. What's your question tonight? Hey, Bobby, you still with us? I know we left you waiting over the break. Okay. Okay.
Hey.
We'll get you back. Nursing homes, many of them, most of them, use arbitration agreements. Okay, what is that? And is that good for the consumer or bad for the consumer?
Well, I mean, typically it's bad for the consumer. Basically, an arbitration agreement is an agreement that two people, it started as businesses would use this to try to resolve disputes without going to the court system. Nursing homes were getting hit with a lot of litigation, so they introduced an arbitration agreement into their contract for people that are being admitted to nursing homes for care. And in their infinite wisdom, the Supreme Court of Alabama upheld all these agreements. But basically what it says is that you do not have a right to try your case to a jury if you are injured in a nursing home and you have signed this arbitration agreement, or your representative has signed this arbitration agreement. Even if they don't have a power of attorney, if your representative has signed the agreement and you're competent, then they're going to enforce the arbitration agreement. And basically what that means is it takes away your right to try your case to a jury. You're going to be left trying your case to an arbitrator who could be a lawyer, retired judge, somebody that's in the know or has seen these types of cases, but it's going to be a less beneficial forum than a jury for anybody that's making a claim. So you're going to be stuck in arbitration, and you're going to be bound by the arbitrator's decision at the end of the day.
What if you get through all of this and the nursing home goes bankrupt?
Well, that's just happened. A major bankruptcy happened in Chapter 11 with a nursing home, multiple nursing homes. There were multiple companies that were part of this shell game, but they have filed for Chapter 11 bankruptcy. They have outstanding settlements where they had agreed to make payments and on certain terms with people, and those cases are in limbo. They're going to be subject to the bankruptcy. A lot of the other, there's $27 million in judgments that I'm aware of against this nursing home that we're going to try to have to sort out to get paid.
We lost Bobby before, but his question was along the lines of he's put a loved one into a facility and they keep falling.
Right.
Like there are no bed alarms. So I thought that was a standard and maybe even a rule.
Sure.
If they don't have proper procedures like that, what can you do about that?
Well, I mean, the standard of care is defined based on what reasonable nurses or facilities should do in the same circumstances in the same industry across the nation. And so it's going to be, there are some things that are going to be apply across the board, but a lot of this is patient specific. So if you look at this situation, you say, okay, what is the patient a fall risk? Most people that reach a certain age in these facilities are going to be designated as a fall risk. Well, did they assess her as a fall risk? Did they create a care plan to try to minimize the risk of falls? So they put her on a low bed. They put a pad by her bed. Are they checking on her more frequently to make sure that she has the ability to go to the restroom so she doesn't try to get out of bed on her own? What are they doing to try to prevent falls? And that's, so if you get a fall, they have to go back and check the plan and revise the plan and try to prevent the plan. But I will tell you that, falls can and do happen in these facilities, and they are not anybody's fault.
Okay.
It is just one of the things that can happen. Now, falls do happen in these facilities, and you can prove that it was because they didn't do what they were supposed to do. But it is the most common type of complaint that we see, and some of them are not avoidable.
Somebody else was writing in talking about a particular employee that is a supervisor and is not doing their job. And they have a lot of list of things that she's not doing.
Right.
Can you report something like this? Is there a state agency? Can you report it anonymously? Because if you tell on your family member's caregiver, they may not treat your family member well, or who knows? Who knows?
Absolutely. So the Alabama Department of Public Health is the outfit in Alabama that oversees healthcare facilities and skilled nursing facilities or assisted living facilities. If there is a problem, then you can, as an employee, report anonymously to these outfits. There's a complaint hotline. You don't have to tell who you are. But if it is a serious if it's a situation that puts patients at serious risk of injury, then they will come and do an immediate inspection. And they will not reveal to the employer, why they came. They will say it's a complaint investigation. So somebody has complained. When they come to the facilities, they interview employees, and they interview employees outside outside the presence of their employers. It's not a situation where you go in there and your boss is sitting there and you're telling them what's going on. These investigators come, they interview individual employees, and their job is basically to get to the bottom of why something happened.
So how do you know a good one from a bad one? Like if you're having to put a family member into a place, how would you evaluate it? How would you figure it out? Can you look up who's got lawsuits against them? I mean, if they have to arbitrate, you may not see what the outcome was, right?
Sure. I mean, it's a difficult thing. You can go to Medicare.gov, and there's a scoring system that says, basically tells you how they do on their surveys. Unfortunately, the surveys are not getting done as accurately or as timely as needs to be done. So, what I would tell people is, look, if you have options at facilities, go to Medicare.gov, look at that. You can call our firm, and I can tell you the facilities that I think are doing a good job and are not doing a good job. But it goes up and down. It kind of rides a roller coaster. So it's hard to tell at any given point.
Yeah.
If you're going to put somebody in a facility or in a nursing home or skilled care or independent living, ask to speak to a current family who's there, and they can give you some idea about what's going on.
Are you allowed to put cameras in your family member's room?
You are allowed to put cameras in a family member's room as long as it's a private room.
Okay.
They don't like you to do that.
No, they
don't.
don't.
Facilities that tell you don't do that or we don't allow you to do that, those are ones you probably want to skip.
Okay, we got this email question. This is the one, this is coming in from Lila, the last one. If a nursing home hires a company to take residents to doctor's appointments and there's a serious injury during the transport, who's responsible for that, the transport company or the nursing home?
Well, I mean, I think it's a situation where you look at it and say if the nursing home has done their due diligence and this is a licensed, registered, company that provides transportation, then they're probably not going to have any responsibility for what happens. It's going to be all on the transport company.
Okay.
Even if they got like, Susie's drunk uncle taking you to the doctor, then that can be a different story.
That's the thing. We had talked about you can also have cases against pharmacies. If pharmacies prescribe you the wrong medication,
sure.
If you get the medication and you see it's wrong, then obviously don't take it,
right.
and that's probably not a lawsuit. What are you seeing with pharmacies and errors with medication?
Well, it's typically is something in terms of the dosage is wrong. I've gotten one recently where there's a serious injury that was caused as a result of a double dose. Instead of 1 per day, it was 2 per day. But it's a medicine that was fairly strong, and so it can cause problems. And so those are the types of things that you really look out for. Sometimes it's just the wrong medicine, and we've seen those, and it doesn't cause really any problems. Somebody said, yeah, I took it, I didn't feel good. Well, it's a blood pressure medicine. Your blood pressure was probably down for, a few weeks. But, so you can kind of, depending on what the circumstances are. So they can run the gamut.
Doctors may or may not cure you. I mean, just because you don't get well doesn't mean that they've done something wrong, right?
Right.
So what's the line for a medical malpractice case?
So Alabama has a Medical Liability Act, and basically the Medical Liability Act governs all claims against healthcare providers. And it says that in order to prevail in a claim against a healthcare provider, you have to prove to a higher burden of proof than a regular case that the doctor did something that no reasonable doctor would do under the same circumstances, and that it distinctly and probably caused an injury. Those are the types of things that you have to prove. Now, simply because an injury occurred, or simply because you had a complication, or things didn't go as well as everybody wanted, that in Alabama is not any indication, or you can't presume that the doctor did something wrong as a result of that. If there are multiple different ways to treat a problem, and a doctor chose one and it didn't work, and there was another one that could have worked, well, that's not an indication or a presumption that the doctor was negligent in that situation. So you really have to prove that the doctor did something that reasonable physicians wouldn't do under the same circumstance, and it caused an injury.
We're going to take a break. Be right back answering more of your questions about medical malpractice and nursing home negligence. Stay with us. Answer tonight. Here's how to get in touch with Michael Timberlake with Timberlake, Lee & Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon handles family law. That's divorce, child custody, child support, modification in Huntsville and all over North Alabama, 256-539-7337. Or you can find her at SharonFamilyLaw.com.
So if you've got a medical mistake case, how long do you have to file an actual lawsuit?
Well, I tell people, in medical cases, it takes us a lot longer to sort it out, get the medical records, evaluate the cases. So don't dally. Do something, contact somebody as soon as possible. You have 2 years from the date of the injury that has resulted from the negligent or the breach of the standard of care by the physician in order to pursue your claim. If you could not have discovered it within that time period, then there's a discovery rule that allows up to 4 years. Okay. But, don't wait. Go see somebody.
Thanks for all your calls and questions, and we'll see you next week.